Protecting a proposed ward. How to become a legal guardian in Texas. Taking on the responsibility of legal guardianship in Texas is a significant decision, one that ensures the safety and well-being of an incapacitated adult. Whether you're seeking to protect an elderly family member suffering from dementia or a loved one who cannot care for themselves, understanding the legal process is essential. The guardianship process in Texas is designed to safeguard vulnerable individuals while providing legal authority to those who assume responsibility for their care. Guardianship is a legal arrangement overseen by the courts, transferring specific rights from an individual, referred to as the ward, to another person, the guardian. It is commonly granted for adults who are unable to manage their own health, safety, or financial affairs due to a mental or physical condition. Texas law recognizes two primary types of guardianship: guardian of the person, responsible for personal decisions like medical care and housing, and guardian of the estate, which covers financial matters such as bill payments and asset management. In some cases, one person may be appointed to serve both roles. The legal process of guardianship in Texas. The guardianship process in Texas follows strict legal guidelines to ensure that only those truly in need are placed under guardianship. To establish guardianship, an application must be filed in the appropriate probate or county court. The application must clearly demonstrate why the individual is incapacitated and unable to care for themselves. Medical evidence, typically in the form of a certificate of medical examination from a licensed physician, is required to support the claim. Once the application is submitted, the court appoints an attorney ad litem to represent the proposed ward's interests. A hearing is then scheduled, where evidence is presented, and the judge determines if guardianship is necessary. If granted, the court will appoint the guardian and establish the scope of their authority, which may be full or limited depending on the ward's capabilities. Guardians must also register with the Judicial Branch Certification Commission, JBCC, and complete required training to ensure compliance with state regulations. State guardianship is an option for those without family members or friends willing to assume responsibility. In such cases, the Texas Health and Human Services Commission, HHSC, or local agencies like the Harris County Protective Services Guardianship Program may be appointed to care for the ward. These agencies ensure that incapacitated individuals receive proper care and protection, with ongoing court supervision to monitor their well-being. How to become a legal guardian in Texas. To become a legal guardian in Texas, certain legal steps must be followed to ensure the proper care and protection of the proposed ward. The process includes hiring an attorney. Texas law requires that a proposed guardian work with a lawyer to file the necessary court documents and navigate the legal proceedings. Obtaining a certificate of medical examination. A physician must evaluate the proposed ward to confirm their incapacity and inability to make decisions independently. Filing a guardianship application. The attorney submits the application to the probate or county court, providing evidence of the need for guardianship. Completing guardianship training and background checks. The Judicial Branch Certification Commission, JBCC, requires guardians to undergo training and a background check before assuming their duties. Attending a court hearing. The judge reviews the evidence and, if guardianship is deemed necessary, appoints the guardian with specific terms outlining their responsibilities. Once appointed, the guardian assumes legal authority over the ward's personal or financial decisions, depending on the type of guardianship granted. They must regularly report to the court to ensure transparency and compliance with Texas law. Understanding full versus limited guardianship. The extent of a guardian's authority depends on the type of guardianship granted by the court. Full guardianship is the most restrictive form, where the ward loses all rights to make personal or financial decisions. This is typically granted when the individual is completely unable to care for themselves. Limited guardianship allows the ward to retain some decision-making rights, such as the ability to manage certain financial assets or personal choices. The court determines the specific limitations based on the ward's abilities. Additionally, guardianship may be permanent or temporary. A temporary guardianship is granted for short-term incapacity, such as recovery from an accident, while permanent guardianship applies to those with long-term or irreversible conditions. Legal guardianship in Texas is a complex but essential process for those seeking to protect a loved one who cannot manage their affairs. Working with an experienced lawyer can help navigate the legal system and ensure compliance with state laws. If you are considering guardianship, the Law Office of Whitney L. Thompson, PLLC can guide you through every step of the process. Contact us today at 281-214-0173 or visit us at 4201 Farm to Market 1960 Road W Suite 360, Houston, Texas, 77068, United States, to secure the future of your loved ones.